All right, great. Well, welcome everyone to the OUP webinar series. My name is Kirsten Leute. I head up University Relations here at OUP. Today, we're having a conversation on Syphius rule updates, what technology businesses and investors should know. In January of this year, the US government issued final rules fully implementing the new powers granted to the Committee on Foreign Investment in the United States, otherwise known as CFIUS. Effective February 13th, 2020, the committee started to exercise its expanded ability to review the national security implications of more foreign investments, in particular, companies with novel or advanced technology, including biotechnology, artificial intelligence, robotics, quantum computing, and advanced materials. So what are the effects seen during the pilot program? What types of investments are subject to CFIUS review under the new rules? And how do these new rules affect universities and university startup companies? To answer these questions and many more, we have two outstanding speakers with us today, and they're back for a return run. So thanks again for coming back to us. Stephen Heifetz and Joshua Grunsbeck of Wilson Sonsini, Goodrich, and Rosati. As I mentioned, they were already on a previous webinar with us on CFIUS that we held back in April 2019. And if you're curious about what they said back then, I think they're going to review some of that today, but also we have that video up on our YouTube channel. So Stephen and Josh, welcome back. And can you each introduce yourselves and provide a bit about your backgrounds? And Stephen, do you want to go first?
Sure thing, we'll do. And thanks, Kirsten. Thanks to OUP and to everybody for your interest. As you mentioned, we did a version of this about a year and a half ago, but there's been a lot of changes in the rules, and we'll update everybody working as we work through the slides. I'm Stephen Heifetz, partner in Washington, in the Washington, D.C. office of Wilson Sonsini. I've been a national security lawyer for the last 25 years, most of that doing CFIUS work. I served on the committee. I was the Department of Homeland Security's representative to the committee for a number of years. And in the last 10 plus years, I've spent most of my time helping US companies and foreign investors navigate the rules.
Terrific. Great. Glad to have you back, Stephen. Josh.
Sure. Thanks for having us back. I'm Josh Grunsbeck. I'm also in the Washington, D.C. office of Wilson Sonsini, as you can tell from the extremely Washington background behind me. I also a national security lawyer for more than a decade now. Before that, I was actually in the government as an engineer, and then did a bit of work for an outside company with DARPA, the Defense Advanced Research Projects Agency, then moved into legal work, and for the last decade or so have been working on national security topics, increasingly CFIUS, as CFIUS has become more important to the investing ecosystem.
We should also add before kicking off that we serve as counsel to U.S. National Venture Capital Association. They're CFIUS counsel, and in particular have been working with NVCA to revise the model documents. Josh has done most of the heavy lifting to revise the model documents to address CFIUS issues. So if you have questions about those model documents, we're happy to address this.
Great. Terrific. Well, thank you. And that's really interesting to know that you're working on that with NVCA as well. So thank you again for coming back and talking with us again. The rest of this webinar for our audience, just to let you know, will be structured as a presentation with Q&A throughout it. We encourage you to ask questions whenever they come up. Our panelists will be looking at those questions, so will I. You can use the Q&A feature on your toolbar. If you submitted a question when you registered for this webinar, we got a few of those beforehand. Stephen and Josh will be addressing those as well. The slides and a recording of this webinar will be available on OUP's partner portal, and a recording will also be available publicly on our YouTube channel. If you are looking at this from the portal, you'll find the downloadable presentation deck actually that they provided to us, and a video on the webinars page under the resources section of the partner portal that we mentioned. So let's go ahead and get started. Stephen and Josh, take it away.
Thank you so much. Really appreciate it. So I think to get started with CFIUS, it's important to know that there's a lot to know about CFIUS these days. There used to be a relatively simple regulatory regime when compared to a lot of other regulatory regimes. Now it's become a little bit more complicated. And so what we want to do in this webinar is tell you what you guys need to know, not everything that there is to know about CFIUS, but what sort of is important from the perspective of being a university startup, being a university tech transfer office. Next slide, if you would, Natasha. A bottom line up front for our purposes, for you guys, is to understand what Syphias is about. It's about foreign investors investing in US businesses. And when a foreign person invests in a US business, it is important to determine whether Syphias approval is either required or advisable. There's two different flavors of Syphias, and we're going to talk about them, both the kind where you don't have a choice, you must go through the Syphias process, and the kind where you can decide for yourself whether you want to go through the Syphias process, but it is possible that if you don't, they will bring you in later. Syphias looks at national security considerations when those national security considerations are created by foreign investments. And as Kirsten mentioned right at the top, one of the things that they're very interested in these days is new, novel, interesting technology, whether it's biotechnology, whether it's material sciences, whether it's artificial intelligence, lots of different interests in lots of different areas. Early decision about whether to obtain Syphias approval can help avoid closing delays. If you do need to get Syphias approval, know as soon as possible, because you can build it into your transaction documents and save yourself time and trouble. Because when Syphias approval is needed, it takes at least 30 days. Investments can be structured, however, to ensure that a company that does need funding, and we know that many startups, including university startups, do need funding very quickly, so that the money gets to the company quickly, even if the rights have to be delayed while the Syphias process occurs. Not all foreign investments necessitate Syphias approval, but most agreements should include some kind of language to mitigate Syphias risk. And that may include a promise from your investor that they're not foreign, which obviously if there's no foreign investment, there's no Syphias. It may be a promise from the US business. We'll talk about all of this as we go through this presentation. Regardless of the election outcome, both US business and the foreign investor may face adverse consequences from failing to address the Syphias risk. Possible requests to condition the foreign investor's stake, have that investor divest its interest, penalties for failure to file. There are downsides to not making a Syphias filing. If there's one takeaway message here, it's, be aware that Syphias can apply. And when you are a foreign investor or you have a foreign investor investing in your US business, take a moment, stop and think, understand where Syphias applies. So can we see the next slide? I want to talk for a minute, given this audience, about why Syphias matters for US investors or non-foreign parties with a stake in the success of a US business. And here we're talking about people like university tech transfer offices and other US parties that invest in or otherwise derive revenues from businesses that seek foreign investment. Those investors themselves are unlikely to be filing with Syphias, but they should still be aware of what Syphias is and what it does, because Syphias risk can be pushed back onto companies by foreign investors. And so existing investors in companies or people who have a stake in the success of those companies will want to make sure that those companies are not unduly taking on Syphias risk by seeking foreign investment. So US-based universities and individuals may not be foreign themselves, but they may find themselves enmeshed in Syphias-related negotiations when they invest alongside a foreign party in a co-investment situation, when licensing technologies to a company in which a foreign party has invested, because the foreign party may become concerned that there's a Syphias issue and may ask for some Syphias terms that push risk back onto the company and by extension back on to the university tech transfer office that's relying on the company to develop the cool new technology that the university has itself invented. Parties that are foreign may attempt to allocate that risk to the target company again, rather than taking it on themselves. So early assessment of Syphias risk is always highly desirable when foreign investors are present. Can we take the next slide? So what are we going to cover today? As Kirsten mentioned, we talked back in April 2019 when the Syphias pilot program was relatively new. Now we have a final set of rules, as opposed to sort of operating under a temporary set of rules, which we did for about 2 years. Now we're sort of in place, we're final. So we're going to talk about the Syphias's new rules, the jurisdiction requirements that changed significantly in February 2020, the Syphias filing fees that were implemented in May 2020, the changes to the mandatory filing rules that were implemented a couple of weeks ago. All of these together add up to the total of the new Syphias rules. And we're going to talk about each of them and how they impact you guys. And then we're also going to talk about the Syphias enforcement team. This is really important because, as I mentioned right at the top, there are two flavors of Syphias. There's a relatively narrow set of transactions for which you must file with Syphias, but a much broader set of transactions that Syphias can opt into reviewing if it chooses to.
And the Syphius enforcement team is the mechanism by which it goes out and finds those transactions. And this team has become significantly more active in the last year. And so parties who think perhaps I don't have a mandatory filing, so why is this a problem for me, should be aware that this enforcement team is out there and looking for transactions. We're going to cover all of this in today's presentation. So Stephen?
Next slide, and the next substantive slide. We're going to, just to level set here, make sure everybody is familiar with the basics. The Committee on Foreign Investment in the United States, or CFIUS as we refer to it, is an interagency group, an interagency committee that is chaired by the US Treasury Department. That's the agency that makes the paperwork move. They move the cases through the system. But it's a committee that includes lots of government agencies, the Defense Department, the Justice Department, Homeland Security. Those are the traditional hawks on the committee. And then the US Trade Representative, the Department of Commerce, the Department of State. Those more traditionally were focused on supporting trade, although in the most recent administration, they've been less enthusiastic about that than in previous administrations. But it is an interagency committee and is about as unwieldy as that collection of agencies might sound. And for any given transaction, there may be dozens, potentially in excess of 100 people who get involved in the review. So it is an unwieldy process. The mandate is to conduct national security reviews of inbound investments. And the committee long has had the authority to approve a transaction or to block it or impose conditions, what are sometimes called mitigation measures, or if the transaction has closed and they have concerns, to force divestment post-closing. If you decide, as Josh mentioned, there are transactions for which it's up to the parties to decide whether to file. Voluntary, or Syphias's discretionary jurisdiction, which is very broad. There's a narrow set of transactions for which filings are mandatory. And if you fail to make a mandatory, a required filing, then in addition to the remedies of blocking the transaction or forcing divestment, Syphias can also impose monetary penalties up to the value of the transaction, so potentially very substantial penalties on either the US company or the foreign investor or both. All of the attention to Syphias has come about really because of legislation enacted over 2 years ago called FIRRMA, that at a high level expanded Syphias's jurisdiction, created these narrow categories of transactions for which filings are mandatory, and infused greater resources into Syphias. And Syphias has been, with the greater resources, doing a bunch of things, including implementing rules required by the FIRRMA legislation, the most recent and effectively last change of which occurred on October 15th, just a couple weeks ago. Additional changes are possible, but as the slide says, the structure is now largely set. So we're going forward, we're reasonably comfortable that we see the Syphias topography as it is going to be for the foreseeable future. Next slide, please. So parties interface with Syphias in one of three different ways, typically. First, they may be required by the mandatory filing rules to file. Second, if they're not required by the mandatory filing rules, as Josh indicated, Syphias may request that they file. It may be subject to Syphias's discretionary jurisdiction. And third, knowing that it's possible that Syphias may reach out and request a transaction, some parties file voluntarily because if they get clearance in advance of closing, that insulates the transaction from post-closing adverse action by Syphias. Those are the three main ways that parties end up dealing with Syphias. A filing involves a set of papers from both the investor and the US business. A short form filing called a declaration is pretty short, as the name suggests, about 5 pages plus some attachments. A long form filing, a notice, usually several dozen pages. When a filing is made, once it's accepted, Syphius may dispense with the transaction in as little as 30 days, but it may take many months. The vast majority of the cases clear the Syphia system without incident. Some require conditions on the deal or mitigation measures, and a few Syphius decides they can't allow to clear and they block the transaction or force divestment.
Can I ask a quick question here, Stephen? So how many, when you're talking about cases, how many cases are we talking about? What's the kind of volume that's going through?
Yeah, so historically there have been, in the last several years, it's been a couple hundred transactions per year. That number may increase over the course. We may get to 500 transactions as Syphius ramps up its enforcement activity, because now it's not only the mandatory filing transactions and the voluntary filing transactions, but a greater number of transactions that didn't file that Syphius is now grabbing. So that may end up adding another 100 or so transactions. But it's in the several hundred, probably not over 500 in the next year or two, but it could grow beyond that.
Thanks, that's helpful.
All right, next slide, please. Gosh, I think you're gonna give the CFIUS jurisdictional overview.
I believe so. So I think if we could move to the next slide, we like to conceptualize the way Syphius works as sort of 3 concentric circles of jurisdiction, each representing a narrower subset of businesses and transactions. So at its broadest, Syphius has jurisdiction over any US business. And that jurisdiction extends to any transaction in which a foreign investor obtains control. Those 3 terms, foreign investor, control, and US business, recur a lot in Syphius land. Control for Syphius purposes is anything more, or it can be anything more, than a 10% stake, a board seat, or the holding of significant vetoes with respect to a company. And I say can be because Syphius's jurisdiction is pretty broad, and they have a lot of leeway to interpret it. It's actually very hard to escape Syphius world into the court system. And so what Syphius has said is that a purely passive investment, an investment below 10% that doesn't grant the investor any significant rights other than just the right not to be diluted, is outside their jurisdiction. Anything above that is potentially, within their discretion, something that can be considered control. A foreign person, for Syphius purposes, is a foreign person or an entity, or, very importantly, a US entity under the control of a foreign person. That means that a foreign person, for Syphius purposes, includes lots and lots of US entities that are under the control of a foreign investor, under the control of a foreign general partner, under the control of a foreign individual human for other reasons. So lots and lots of US entities are actually foreign persons for Syphius purposes, something that's important to keep in mind. Third, a US business. Well, what's a US business? It's anybody who's engaged in commerce in the United States. And that means that, for example, Syphius's authority extends to multinational conglomerates that may be based in Germany or Italy or France or China, but that maintain offices here in the United States, maintain operations here in the United States. If there's a change of control over those entities, that change of control can be subject to Syphius's review. So that's a pretty broad grant, as you can imagine, with those broad terms. This outer circle of jurisdiction actually is a pretty broad circle. Tens of thousands, if not hundreds of thousands of transactions every year fall into it. As Stephen just said, though, only about a few hundred actually go through the Syphius process. And that's because, as we've said, there's no requirement to file with Syphius when you are in this outer circle of jurisdiction. It represents the largest subset of transactions Syphius can choose to review, but Syphius has to decide that there's some reason for it to review that transaction, either because you proactively, voluntarily go before them and file it, or because they, using their enforcement powers, go out and seek out the transaction saying there's a national security reason here for us to take an interest in this. So can we see the next slide?
Can I ask a quick question, just because we've gotten a couple questions in now, and you may be answering this later, but how does Syphius actually scout for those transactions? Well, I guess when its enforcement committee is doing that, or is that something you're going to be answering in a bit?
We
Yeah,
are going to.
Oh, sorry. Go ahead, Stephen.
We are going to talk in a little bit about CFIUS's enforcement activities. The short answer is they are look at two sides of the equation. How sensitive is the US business, and is the foreign investor a particular concern? And these days, they've been particularly focused on Chinese and Russian transactions. We'll talk about this in more detail in a bit.
Okay. And then can I ask that one other question, which is just actually if someone has dual citizenship, US and foreign citizenship, do they qualify as a foreign person or not?
Yeah. Josh, you want to take?
Sure. So historically, Syphias has considered people who are dual citizens to be US citizens for their purposes. Now, could they at some point, given their intense focus in recent months, as Stephen says, on Chinese and Russian transactions, think about that again if the second citizenship were Chinese or Russian? Maybe. But historically, they have not been that concerned about dual citizens.
Great. Well, thank you for taking that question break.
Absolutely. So then there's a second circle of Syphias jurisdiction that's important to talk about. And this is new. This was added in FIRRMA. That first circle was their historical jurisdiction. The second circle is their jurisdiction over what the new laws call TID US businesses. Those are businesses that work with critical technologies, infrastructure, or sensitive personal data. Technologies, infrastructure, and data being the TDI and the D. A business that designs or makes or tests critical technologies, a business that owns or operates, maintains, services critical infrastructure, a business that maintains or collects sensitive personal data on US citizens. These are TID US businesses. And with a TID US business, Syphias's lower bound on jurisdiction is not control, it's even some sub-controlling investments. If a foreign person is going to get merely a board observer, let's say, or a foreign person is going to get access to material non-public technical information, which means, for example, access to the underlying technology of a company that works with critical technologies. If they're going to get involvement in substantive decision-making, if they're going to have the right to advise the CEO, even if it's on an informal basis. Any of those things can constitute a triggering right for a TID US business, and any of those things can give Syphias jurisdiction if they're a foreign investment into a TID business that grants those rights. However, like the first circle that we just looked at, these rights are elective on Syphias's part. This does not mean that you have to file with Syphias if you have a TID business and you're granting one of those rights. It just means that Syphias, again, has the right to bring you in. So let's move to the next slide. And then this is the third and the smallest circle. It's inside the set of TID US businesses. There are a set of businesses that must file with Syphias. Here is where you lose the elective piece of the puzzle. There are two types of transactions within the world of TID businesses that must file with Syphias. The first are transactions in which a foreign government-backed investor obtains a substantial interest in a TID US business. And we'll talk about in a minute about what a substantial interest is. The second is when the US business is a critical technologies business. Again, TID, technologies, infrastructure, and data. Critical technologies is one of the ways in which you can be a TID business. If you are a critical technologies business, and if the specific foreign investor that's investing in you would be required under US export control law to get a regulatory authorization if you were exporting your technology to them, then they would also be required to get a CFIUS approval if you are selling your technology to them. That's basically the way the system works now. This is a very recent change. This second prong of this test appeared in rules that just took effect a couple of weeks ago, actually. And this was the last final tweak that Cypheas made before sort of having all of its FIRRMA rules in place. One question that we get a lot is, okay, great, those are the required transactions, so we're done, right? If we're not in one of those two sets, we're done. And the answer is no, because of Syphias enforcement, as we said a couple of times now. We're going to have a section on that. Stephen's going to talk about Syphias enforcement in a minute. But I just want to emphasize for a moment before we get there, exactly what you need to think about in order to know whether you have a mandatory transaction. So can we have the next slide, please?
We have a couple questions that popped up that I think we can answer quickly. First is if a company has US, it's a foreign business, but has US branches, and the foreign company is receiving an investment, should they consider CFIUS? And the answer, unfortunately, is yes, they need to at least consider the CFIUS implications, because if it is a foreign business that has US operations, it is a US business within the meaning of the CFIUS rules, at least those US operations are. So it doesn't mean that you have to file, but it does mean you need to think about the CFIUS implications.
Right. And I do see that we also got the question, is there a list of foreign government-backed investors? The answer, unfortunately, to that also is no. There's not some universal acknowledged set of foreign government-backed investors. There are foreign government-backed investors who we see a lot and who I imagine you, even sort of in the venture space, might see a lot. People like Temasek and GIC out of Singapore. People like Mubadala out of the Abu Dhabi, out of the Gulf states. Certain very active sovereign investors, who basically are sovereign funds belonging to particular states that are out in the world of venture investing, looking to invest in young companies. And those are the most common form of government-backed investors that we do see.
And on the question as to whether if a US business needs an export control license to export the technology, is a CFIUS review going to be required? A CFIUS review is important if there is an equity investment but being made by a foreign person into that US company. And the fact that an export control license is required is indicative but not dispositive as to whether a CFIUS filing would be required. But certainly a CFIUS, thinking about CFIUS will be important if that business receives a foreign equity investment.
All right, so then moving back to the two mandatory filing rules that we just discussed, I want to sort of emphasize each of them in turn and discuss the kind of analysis that you would do at a high level to understand whether you actually have to file a CFIUS where you don't have a choice. So the first of the two rules is the rule that I described as the critical technology rule, related to companies that have critical technologies. And there's a 5-part test, and this test is conjunctive. The answer to all 5 of these questions must be yes for you to have a mandatory filing for a critical technologies business. The first is there a US business? And that's that broad definition of US business that Stephen just alluded to in the answer that he just gave. It does include foreign investments that happen, foreign companies that have operations here in the United States. Second, is there a foreign investor? Third, will the foreign investor receive control or other triggering rights? That means control or some of the other rights that we talked about when we talked about TIV businesses. So board observer, material not public technical information, involvement in substantive decision-making, one of those triggering rights. Fourth, does the target deal in critical technologies? And this is sort of an important thing to stop on here because critical technologies is a concept that occurs a lot in CFIUS land. Critical technologies is defined by reference to a number of specific US government lists, each of which lists items that are highly controlled. And you would not be surprised, for example, to find that one of those lists is maintained by the Nuclear Regulatory Commission. It talks about nuclear materials. Another one of those lists is the list of select agents and toxins that's maintained by the CDC, the FDA, a few other folks. Items that are very controlled. So if, for example, you work with anthrax, you might find yourself to be a critical technology company. The single biggest list is a set of items controlled under the Export Administration Regulations on what's called the Commerce Control List. And the Commerce Control List, it runs to the hundreds and hundreds of pages, and it controls a lot of different items that are both dual use, what the US government considers, to have standard commercial uses, but also to have potential military uses. And so the list of critical technologies is quite long, and there's not an easy place to go for reference to what is and is not a critical technology. Moreover, the last of the 6 lists that makes up the definition of critical technologies are so-called emerging and foundational technologies. And these are new technologies that are being designated on an ongoing basis by the Department of Commerce. We just had a designation of a few of them 2 weeks ago, items that were added to the Commerce Control List and so newly became critical technologies. And so this, whether or not you have critical technologies, is a really important question when we think about whether you have a mandatory filing. And also, it's a question where the goalposts do move from time to time because the Commerce Department designates new emerging and foundational technologies on an ongoing basis. It's been asked to under the law that created FIRRMA. Fifth, and finally, does the foreign investor need to acquire regulatory authorizations in order to acquire the critical technologies? So critical technologies, again, defined by reference to these series of lists. Each of these lists has its own requirements for giving access to foreign parties. There are requirements under the EAR, the CCL. There are requirements under the International Traffic in Arms Regulations, what's called the U.S. Munitions List. Each of them has their own special set of regulatory authorization requirements as to who can access these controlled technologies. And what the fifth test here is asking is, are there folks who are either the investors themselves or certain owners of the investors, people with a 25% stake in the parties or greater, are any of those folks subject to those requirements when they access the technologies in question through licensing or other means? And if they are, then they also have a mandatory filing at Syphilis. This prong, again, recently replaced a previous prong having to do with what industries the technologies were in. Now, however, we deal more in this question of regulatory authorizations. So 5-part test, it is conjunctive. If the answer is no on any of these fronts, there is no mandatory filing. So can we take the, sorry, go ahead, Stephen.
A question that popped up is the mere fact that a technology is on the Commerce Control List sufficient, and don't we mean to say that the relevant consideration is whether an export control license is required? That is correct. If it is EAR 99, then it is not a critical technology. And so the question under this test is you have to determine whether it's critical technology that will not include EAR 99. And then the final prong of the test involves whether a license would be required to the specific foreign investor or stakeholders in that foreign investment.
Right. And I think this goes to another question that popped up, which is sort of what's the difference between 4 and 5? So let me sort of hit each of those in turn quickly. 4 here, the question of whether or not you are critical technologies relates to your position on one of these lists. And in particular, I think important to note, given the prior question, just being on the Commerce Control List alone is not enough. You have to fit into certain specific categories on the Commerce Control List. You have to be controlled for national security or chemical weapons, biological weapons reasons, for other reasons that exclude, for example, anti-terrorism, which is another control that exists on the list. And so question 4 is, are you on one of these lists in a sufficiently controlled way to make you critical technologies? Question 5 is then, do you need a license? Does the specific foreign purchaser in question here need a license in order to access the technology that is on the list, if it were being licensed? Because if that's true, then it also needs a Syphias approval when that technology is being purchased. Basically, it's trying to marry up the export control permission system to the investment permission system. Sorry, one more question that came across. Don't think this question was fully answered. How does Syphias scout for transactions that were not disclosed but are potentially of interest? I promise you that is literally the next section. We will discuss enforcement at some length, and we'll all have a good time doing it.
I'll hold you to it, so I'll come back to it.
Sounds good.
So then second, the other mandatory filing test for you to be aware of is the substantial interest test. And this, again, is a test that is a conjunctive test. All of these things have to be true. First, there has to be a U.S. business. Second, the foreign investor in question must be one in which a foreign government has a substantial interest. And for these purposes, a substantial interest means a 49% or greater interest, direct or indirect. And so, when we're talking about this, again, most often we're talking about sovereign wealth funds, these large-scale foreign investors who invest in pretty significant ways into the U.S. economy. Those are the types of investors that usually have a foreign government with a substantial interest in them. Third, will that investor in turn receive a substantial interest in the U.S. business? And Syphias, being the confusing regime that it is, it's defined substantial interest in 2 different ways. Substantial interest for these purposes is a 25% or greater interest, direct or indirect, in the U.S. business. So you need to have a foreign investor that takes a 25% stake, and that foreign investor must be 49% or greater owned by a foreign government. That's the situation. And then fourth, and finally, is the target a TID US business? Is it one of these sensitive TID US businesses that we mentioned before that deal with critical technology, critical infrastructure, or sensitive personal data? So if all of these tests are met, then you have a mandatory filing as well. A couple of questions that have come in. One, could Syphias be interpreted to directly apply to US university licenses to foreign companies, where the US university constitutes the US business and the foreign licensee constitutes the foreign investor? It's a great question. So Syphias applies to investments generally. Basically, it's the Committee on Foreign Investment in the United States. It's right in the name. And so as a traditional matter, they do not have jurisdiction over licensing agreements at all. However, if the licensing agreement looks like the acquisition of a US business, it's in the form of a licensing agreement, but as a practical matter, you're taking over, for example, the paying of certain employees and certain customer contracts that the business already has under the rubric of what appears to be a licensing agreement, then Syphias can take jurisdiction on the theory that you're trying to avoid their jurisdiction. So to the question, if you're a US university and you're licensing a technology to a foreign company, that probably won't bring you within Syphias' jurisdiction. But if you're a US university and you have an existing operation with respect to that technology, and you're employing folks in-house at the university to develop that technology, you've started licensing it to US businesses, and then you take that entire operation and you license it to a foreign company by effectively having them hire away all the employees at the university who are doing that work, then that does start to look like a transaction that might be subject to the Syphias jurisdiction. A traditional license, though, probably not.
To take another question, is a foreign co-founder who has a significant stake in the company considered a foreign investment for Syphias purposes? The answer is generally no. One could imagine circumstances in which Syphias tries to reach a subsequent investment by the co-founder after the company is up and running. But there is a rule of thumb at Syphias that if, in fact, it's embedded in the regulations, Syphias doesn't have jurisdiction over greenfield investment. So the creation of a company is not subject to Syphias's jurisdiction, and therefore, most of the time, they're not going to look at foreign co-founders.
And in a couple of enforcement cases that we have recently dealt with, that has been an issue, and Syphias has been receptive to the argument, the continuing argument, despite their general paranoia these days, that greenfield investments really are outside their jurisdiction. So I think that takes us to the end of this section and to the long-awaited section on Syphias enforcement and how it operates. And for that, I'll turn it back to Stephen.
So to end the suspense right off the bat, how does Syphias scout for transactions not filed that are of interest? Well, a lot of different ways. Google is a primary way. Not kidding about that. The media generally, filings, government filings around the world, whether in the US, federal or state, or foreign filings to government agencies. And Syphias also, of course, includes US law enforcement and the intelligence community. So they've got a lot of mechanisms and resources at their disposal. They have notably purchased subscriptions to things that probably all of you have, PitchBook and other data sources about transactions, especially in the venture capital space. That has become a recent focus. And then in addition, the enforcement unit that we're going to talk about here has put up a website. You can go and find it. It's part of the Treasury Department Syphias website that invites tips from competitors about transactions that haven't been filed. So lots of different ways, but certainly we advise companies if they've decided they don't want to go through the Syphias process and it's not mandatory, they should not have a lot of press about the transaction because that is the most obvious way that Syphias finds out. Syphias, as Josh made clear in the earlier segment, Syphias has a broad jurisdiction, not only transactions that result in control over a U.S. business, but also investments that have triggering rights into TID businesses. And so as to that broad set of transactions, CFIUS can block, they can impose conditions, they can force divestment post-closing, and only obtaining CFIUS clearance insulates the transaction against post-closing adverse action by CFIUS. But CFIUS, as we've been saying, CFIUS has jurisdiction over tens of thousands of transactions, and it's only interested in a small subset. So I said a minute ago, sort of the mechanisms by which it searches: media, government filings, competitor tip-offs, U.S. Law enforcement and intelligence communities. What are they looking at? They are looking at who is the foreign person, what's their threat profile, how sensitive is the U.S. business, what is the relevance to U.S. security. Timing, and well, the parties are thinking also about timing and cost considerations when they're deciding whether to file. The parties have to think about the first two factors as well. CFIUS isn't usually thinking about timing and cost considerations, but the parties certainly are. Sometimes, if the parties say, look, this transaction, tell us about the CFIUS risk. We understand it's not mandatory. This transaction has to close at the end of this week. That's the answer, right? If it's not mandatory and it truly has to close at the end of the week, that's not enough time to go through the CFIUS process, so that's the answer. CFIUS enforcement practices and the parties' tolerance, risk tolerance, and whether and how they can allocate that risk between the parties, those are all things that the parties should be thinking about.
So we did get a couple of additional questions in. I think one really important, which is how long after a transaction has been completed can a CFIUS review be imposed? Is there a time limit beyond which, if you chose not to go get a CFIUS approval, you're safe? And the answer is no, effectively. Unfortunately, it is the case that CFIUS has no statute of limitation. And so, what you do when you don't voluntarily file is you decide the tail of risk that remains is small enough that you're okay living with it in perpetuity. That's a totally reasonable and rational decision, but there is no period of time after which you are done if you don't go and seek CFIUS approval voluntarily and you are within their jurisdiction for the investment that you seek. Another question that we got is, what if a university invests funding into a startup separately from the license executed from the start of the university? Could CFIUS apply? And the answer is, if the university is foreign, yes, certainly CFIUS could apply. If the university is not foreign, then the answer should be no. CFIUS would not apply to that investment in the sense that there would be no foreign investment that CFIUS would be able to take an interest in. But of course, if the university is in there co-investing with other investors who are foreign, then the university may care about the CFIUS terms that the business signs up to, because they may be pushing risk effectively back onto the university as a US investor, while the foreign investor disclaims that CFIUS risk. And we'll talk about contractual terms and the allocation of CFIUS risk in a minute.
Another good question: can CFIUS trigger a re-review if they approve the initial investment, but then it becomes sensitive? Usually not. Usually the CFIUS, it depends in part on the nature of the filing and whether it was a controlled transaction. But usually the CFIUS review is final. If there is a subsequent investment into the US business, they can review that new investment because they're looking at both the US business and the foreign investor. So particularly if there is some new foreign investor, they can take a look at that. But they don't typically review the same transaction unless they believe that there was fraud in the information, inaccurate information that was provided to them. All right, next slide. We got a question about whether CFIUS uses particular company to search for transactions. We're not privy to the exact tools that CFIUS uses. We have a general idea of how they do it, but today we don't know the precise which companies they're using to do their searching. All right. While parties in non-mandatory cases, as we've emphasized, have discretion about whether to file, if they don't file, they're taking risk. And as we've said, there is no statute of limitations. Syphilis indefinitely can grab the transaction. And in fact, as we've found with this new monitoring and enforcement team having been set up, Syphilis is not focused exclusively on mandatory filing transactions, but is focused on the much broader array of transactions over which they have jurisdiction. They insist that they are looking at transactions that don't have just Chinese and Russian investment. And while we understand that in some cases they have grabbed transactions that don't involve Chinese or Russian investors, the vast majority of the transactions that we're aware of do have a China or Russia element to them. So that is certainly a flag to Syphias.
So we have another question that came in about what happens if the rules change. What happens if they countries or technologies that they care about are altered, and can something be re-reviewed retroactively on the basis of the updated rules? So I think that's a great question, and I want to disambiguate countries and technologies. So the critical technologies definition is a definition that's always prospective. It's not retrospective. And so if critical technologies change, that, for example, might create a new mandatory filing rule for critical technologies, but it will only apply going forward. It will not retroactively apply to investments that the parties who have those critical technologies took before they were designated as critical technologies. That doesn't mean that Cypheas won't take more of an interest in transactions involving those technologies if they didn't review those transactions already. And that's equally true with respect to countries. If next week the United States is at war with Canada, which I'm not totally putting past us at this point, then it may become the case that we think more aggressively at Cypheas about exactly what technologies can be exported to Canada. And in that case, parties who accepted Canadian investment into sensitive technologies may become of more interest to Cypheas. If those deals were filed with Cypheas, that does not provide an opportunity for them to re-review, right? Once a deal is filed, you have obtained safe harbor and you are done, unless you lied to Cypheas during the review. But if you chose not to file a transaction on the theory that the transaction was not interesting to Cypheas at that time because we didn't care about Canadian investment and now we do, you have left the door open for Cypheas to say, well, now actually we would like to take a look at that transaction. It was within our jurisdiction before. We chose not to look at it because we didn't care about Canadian deals, but now we do. And so yes, it is the case that does leave the door open for Cypheas to take a look at a transaction that happened a few years ago in light of their new geopolitical concerns.
We've got another good question. Cognizant of that we're running short on time, Kirsten, I assume you'll send the slide. We may not get to all of the slides, but will you?
Right, we'll send them out. Yes.
Okay. Yeah, because a lot of good questions. Can Cypheas block deals based solely on homeland security considerations or national security considerations, or can they block deals for any reason, including trade reasons? So Cypheas's mandate is national security. However, that is, as I'm sure folks recognize, a malleable term. And so there are certainly lots of situations with which we're familiar where Cypheas seems to be acting on things that are tangential to national security. They will always explain their reasons by reference to national security, but in certain circumstances that has become pretty attenuated. But there is quite importantly, there is effectively no oversight with respect to Cypheas. It is impractical to get to court with respect to Cypheas. There's been only one piece of Cypheas litigation in history. And so that means that Cypheas has a great deal of leeway. Let's see, the next slide, they ended this slide, it's mostly China and Russia related transactions that seem to be focused, but not limited to that. Next slide, please. So if you're curious, how does CFIUS begin an enforcement action where in a non-filed case, the transaction parties, usually the US party, will get an email like this. This is an actual redacted email sent to a party. We're from the Department of the Treasury and we want to talk to your management about a time-sensitive matter. Usually at that point, the management will reach out to outside counsel, and outside counsel will typically take over from there. We have had, this email looks sort of fishy. So we have had clients think that this is spam. And in fact, one client threatened the Treasury Department to threaten that they'd call the FBI on the Treasury Department, which the Treasury Department was amused about. So that's how it begins. Next slide, please. So what can happen after this process begins? Well, initially, CFIUS will ask a standardized set of questions to determine whether they have jurisdiction, and then follow up, assuming they have jurisdiction, with questions geared to determining whether there's a substantive concern. They may ask the parties to file or suggest it or demand it, and at any point the parties can make a filing, but usually by the time that CFIUS has inquired, the CFIUS is likely to treat the transaction if it ends up being a filed case. Not all of the outreach by CFIUS ends in filed cases. Sometimes they decide they're not interested. But if it does end up being filed, it's much more likely that that the parties are going to have a tough time than if the parties had made a filing at the outset had made a voluntary filing. CFIUS, of course, at the end of this process can block the transaction or force divestment. If the parties had failed to make a mandatory filing, they can also impose monetary penalties. Parties always have an obligation to rule out that there's a mandatory filing. If the parties are risk averse and if they have time, then making a voluntary filing can make sense. Regardless of whether they make a filing or not, parties, if it's a US company and a foreign investor, they really should at least consider specifically allocating the CFIUS risk in the financing document. Right. Next slide, please.
So I will briefly go through structuring and risk allocation. This is really important from the perspective of parties who are doing investment agreements. And I don't want to sort of talk about it at length because I know we're short on time. But I think the key point is that there are ways to allocate risk contractually if you choose not to file voluntarily. And many, many parties do not file voluntarily. So I think that it's important to know, first of all, with respect to this slide, which I'll just talk to you for a second, that there are ways to structure transactions so that the money can get into the business quickly while the parties defer the CFIUS review until the rights are granted, they defer the rights granted until the CFIUS review occurs. So basically, the foreign investor takes a passive stake in the US business, then goes through a CFIUS review process, and then takes the remainder of the stake that they intended to have in the business. So that's one piece. And then if we go to the next slide, when you want to not file at all, there are also risk allocation mechanisms that you can use there. So for example, common protective provisions in this regard, and you'll see all of these in the NVCA model documents, which as Stephen mentioned at the top, we had a hand in creating, will be a representation, for example, from the US business side that you don't have a critical technology, so the foreign investor shouldn't be worried. From the foreign investor side, it may be a representation that the foreign investor is not actually a foreign investor, right? It's a US entity, and you may be concerned about who is behind that US entity with foreign LPs, foreign GPs, and so you seek a representation from them that they are not actually foreign, thereby assuring you that CFIUS won't be a problem. Terms like that exchanged between the parties are ways to push risk back and forth if indeed there is a CFIUS review down the line. More aggressive measures that sometimes foreign investors ask for might be things like forcing the company to repurchase its shares if CFIUS has any questions, which obviously puts a substantial amount of risk back on the company that they might be forced to make a substantial expenditure at any time if CFIUS has questions. A, it's not clear that that solves your CFIUS problem entirely, but B, also this is why, if you're a US investor, you need to watch your companies because you want to make sure they're not signing up to terms that give the foreign investor all of that risk. And we got another question in, which I'll do quickly. Is there an appeal process? The answer is the way the CFIUS process works is that CFIUS makes decisions. And if CFIUS says the transaction needs to be blocked, it doesn't do it itself. It says to you, the parties, we don't see a path forward here. We think you should withdraw. If the parties don't, it's not actually CFIUS who makes the decision. It's the President of the United States. CFIUS refers the transaction to the President. And so in a very real sense, the President is the appeal process. There is a way to get out of the CFIUS process into the courts as well. But as Stephen has said, it's not easily accessible.
It's effectively only due process claim. The parties could claim in court that their due process rights were infringed, but as Josh said, the real appeal is to the President.
All right, so then I think that moves us to a very quick section that we can possibly do on.
Terrific. I thought if we could take just a few minutes going through the filing mechanics. I know people may need to drop off, but if we could at least get that recorded so they could watch it later, that would be great.
Sure. So there are two types of filings. There is a short form called a declaration. It takes a few days to a week to pull together. When there is a mandatory filing, that declaration has to be filed 30 days before closing. Once Syphias responds 30 days after they have accepted the declaration as complete, they can tell you that the case is clear. That's what you want. They can give you a no action letter or a shoulder shrug that says you can close your deal, but we reserve our rights to ask for a long form notice down the road. They rarely have done that. That is, they rarely have followed up to ask for that long form notice. And so parties generally treat a no decision as tantamount to a clearance, or they can say you need to make a long form filing. If the transaction is going to be sensitive, then starting with the declaration is generally not a good idea because you're likely to just waste 30 days if you know that at the end, Syphias is going to say, you need to make a long form filing. Next slide. For the long form, it takes usually a couple weeks to pull together. The CFIUS process takes several months. They start with a 45-day review process. They can add an additional 45 days. The benefit of the notice process is you are guaranteed to get a definitive yes or no at the end of the process. Filing a notice, though, does have a filing fee associated with it, in contrast to a declaration that doesn't require any filing fee. So the filing fees for notices are geared to the value of the transaction, up to $300,000 for a transaction of $750 million or more. Next slide.
So before we sum up, I think just one thing to note, CFIUS has become a real buzzword in the transactional community across the board and sort of stands in for a lot of national security concerns. I think important to note on the side here, we are a broader national security practice. There are a lot of other national security concerns that can impact investors in universities. And it's worth noting that people sometimes think of these as CFIUS issues, and we just want to take a moment to disambiguate some other areas that are important to know about, but that aren't CFIUS. So, for example, you should be aware that export controls are changing. When the designation of new emerging and foundational technologies happens, which we mentioned earlier, that's not just a designation for CFIUS purposes. That's also a change in export controls rules. And that really can affect, I think we got a question earlier, for example, about what happens if you, a university, are licensing technology to a foreign party. Export controls apply in that situation. CFIUS may not, but export controls are still very much a US legal regime that are applicable to that situation. And so the changing emerging and foundational technologies are relevant even outside of the context of CFIUS. Similarly, we have seen recently the US government using its broad authorities under a statute known as IEEPA, which is the statutory basis for things like US sanctions orders, to issue orders to try to prevent the use of certain communications technologies, technologies that we know are in wide use on university campuses, among others. And so, universities should be aware that IEEPA powers, these sort of strong emergency powers that the president has to take action in national security situations, can be being used, especially these days, in new and surprising ways. Third thing to mention here is the National Defense Authorization Acts in recent years have included a number of restrictions on the use of, for example, research funding, where the NDAAs say that government research funding may be conditioned on not having certain telecommunications equipment in a university network, or not having a certain kind of institute, specifically these Confucius Institutes, which are funded in part by Chinese government money, on campus. And so be aware that, through defense funding mechanisms, the US government is also out there trying to influence university behavior. And finally, through prosecution, the Justice Department is out there acting concerned, has become much more concerned over the last few years about foreign espionage related to university research and university technologies. And in particular has kicked off what it calls a China initiative to look at Chinese investment and Chinese involvement in US universities. And so, for example, earlier this year, we saw the indictment of Dr. Charles Lieber at Harvard, who was found to have taken some money from the Chinese government, which is not illegal, but then lied to the FBI about it, which is illegal. And so, I think all of these things are national security considerations that we know that universities and companies with fancy, new, exciting technologies that universities have developed are running into. These aren't Syphias concerns, but they are national security concerns. And so university investors and university startups should be aware of them. I think that brings us to our final takeaways.
Yeah, and we can, Kirsten, I don't know if you want us to go. These are just tips sort of extracted from the information that we've just been through. So folks can perhaps read them at their leisure, and we're happy to respond if folks have questions after they've taken a look.
That would be great. And let's go ahead and go to the last slide, Natasha, just so that everyone can see. Josh and Stephen did provide their contact information. So if you do have follow-up questions, you can certainly reach out to them. And those of you who have joined us today, thank you so much. There will be obviously a survey that's going to come up in your chat box, but also I think when you leave. So please let us know your thoughts on this webinar as well as future webinars from OUP. Really do value that. And this webinar actually came as a result of someone asking about what happened with Syphilis. What should we be thinking about? We heard this other webinar previously. We want to know what the updates are and what we should be doing. And Josh and Stephen, thank you for coming back and talking with us. This was really fantastic. Thanks for getting all of those questions answered throughout this. I imagine you may be getting some follow-up as well from our universities. Obviously, they work very heavily with their researchers and startup companies, and this is a topic because there are a lot of working with foreign entities and foreign investors, how that will play out for them. So thank you so much for joining us today. Audience, again, reach out to Stephen and Josh if you have any further questions. Thank you everyone for your participation in our webinar today, and enjoy the rest of your day.